Welcome to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. And now your hosts, Tim Kowal and Jeff Lewis.
Most appellate attorneys that we talk to would love it if the court were to issue more tentative opinions or focus letters. And your division's practice when you're on the bench was to issue focus letters before oral argument, which would tell the advocates what issues the panel was particularly interested in hearing about during oral argument. What was your experience like with these focus letters? Was it positive?
Yeah, it was definitely. And I'll go back a little further to say that I wasn't the midwife for the idea of tentative rulings, but I was there at the birth. And the idea on the trial court was that you didn't make people come to court. You know, you put it on the phone line, what the ruling was, and they wouldn't show up. But on my trial bench, I most frequently used it to say, parties appear. I want to hear your argument on this point. And I would say, parties appear, and I'm interested in this. And they would show up. And that carried over to the Court of Appeal. On the Court of Appeal originally, when I started, the idea was, well, if we give them a tentative ruling, they're just going to come and argue with us and tell us we're wrong. And we've already written the opinion, so we don't want to hear it. So the compromise was really the focus letter, which is kind of like saying parties to appear. We want this is what we want to hear about. And it also avoids that concession problem I discussed, where there are some issues that aren't going to be important to us. So I think it worked really well. I know that some of the divisions, I think in the first district, are now posting their drafts, which was done in the fourth district for many years. And I have no objection to that either, but I think the focus letter makes the argument better, because you're actually saying this is what we're interested in, rather than here's the draft, and once again you can come and argue with us and tell us we're wrong, which is not really as helpful. It comes from my actually thinking that oral argument is important, which is, as I said, surprises me that so many people waive it. And it may be appropriate in routine cases, but on the other hand, if it's worth appealing, I think I'd like to talk about it.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.